I welcome each and every one of you panelists and visitors to today's hearing on the history and enforcement of the Voting Rights Act of 1965. I will now recognize myself for an opening statement. The right to vote is the most fundamental right of citizenship in our democracy. Everything rests upon the voter and the constituent. Yet for most of our nation's history, too many of our citizens, and particularly African Americans, were denied this most basic right, especially in my home district, the Deep South. In large measure, it took an historic march, and before that, an attempted march thwarted by the Alabama State Troopers, led by our own John Lewis, later joined by Dr. Martin Luther King from Selma to Montgomery, to bring the nation's attention to the horrific conditions faced in Alabama and throughout the South in denying people the right to vote, and even to protest and march. This protest really led to our Congress passing the Voting Rights Act. On August 6, 1965, our nation took that momentous step towards correcting the injustice when President Johnson signed into law the Voting Rights Act. John Lewis was there to witness that historic occasion. 100 years after the Civil War, 100 years after the Civil War, it took America to pass a Voting Rights Act to see to it that African Americans were not discriminated in. How many coins could be put in a bottle of water? Unless you could tell exactly how many coins might have been in a bottle of water, you couldn't vote in Alabama, Mississippi, other states in the South for 100 years. It's because of the recent developments that we've seen in our country, with our Supreme Court having ruled the Voting Rights Act unconstitutional and the failure to be able to pass an act in the most recent Congresses to renew it, that this subcommittee will dedicate itself, this Congress, to, among other things, restoring those protections by reinvigorating enforcement of the Voting Rights Act, including through the revitalization of its most important enforcement mechanism, Section 5 pre-clearance provisions. It's astonishing to me, as someone who witnessed as a young person the signing of the Voting Rights Act and the historic significance that had in our country, the Civil Rights Act of '64 and the Voting Rights Act of '65, that here we are nearly 50 years later, over 50 years later, and we're dealing with it still. This hearing is the first in a series of hearings of the Voting Rights Act before this subcommittee. Our focus today is on the history and enforcement of the Act, for we must understand how we arrived at this point in history so we can discern our best path forward. Before the Voting Rights Act, the state of voting rights in the Deep South was, as I've described, abysmal. That's probably the high point. In the mid-50s, more than 80 years after adoption of the 15th Amendment, which prohibits states from denying citizens the right to vote on account of race, color, or previous condition of servitude, and gives Congress the power to enforce this prohibition, only 1 in 4 eligible African-American voters in the South was registered. That was 80 years after the passage of that constitutional amendment. This low number was a result of decades of backlash against political participation by African Americans beginning after the Civil War, being given a booster shot by Jim Crow and the awful 1876 presidential compromise. This backlash included political violence by the Klan and others who kept black voters away from the polls with guns, whips, lynching, and intimidation at all points. After Reconstruction, short-lived, Southern states enacted numerous measures to disenfranchise African-American voters as part of what came to be known as Jim Crow. These measures include poll taxes, literacy tests, the disqualification of convicts from voting, and many other measures designed to block African Americans from voting. And I should mention also the construction of many statues venerating Confederate heroes as a symbol in many town squares and public areas to say to blacks, don't you even think about asserting your rights because we're still in charge. That's what those statues meant. As a practical matter, these tactics, combined with Congress's inaction, denied African Americans the right to vote, notwithstanding the 15th Amendment's guarantee of equal voting rights. After almost a century with the substantial efforts of the Civil Rights Movement, Congress finally asserted its 15th Amendment authority, passed the Voting Rights Act with Lyndon Johnson as president. One of the key features was the Section 5 pre-clearance requirement. Under this requirement, certain jurisdictions, predominantly in the Deep South, that had a history of discriminatory voting measures were required to obtain the approval of the Justice Department or a 3-judge panel before any proposed changes to voting practices or procedures could take effect. The pre-clearance requirement was crucial to vigorous and effective enforcement of the Act's guarantee of equal voting rights. It prevented widespread harm to minority voters and avoided expensive and cumbersome litigation by rightly settling as the default outcome the prevention of potentially discriminatory voting practices from going into effect. The preclearance requirement instead appropriately placed the burden of proof on the covered jurisdictions to show the changes to those voting practices would not be racially discriminatory. Those states that had preclearance requirements were predominantly in the Old South, and those states that had white and colored drinking fountains, days for quote-unquote coloreds to go to public libraries and zoos and all the other activities that were so opprobrious that were prevalent during that era. With this robust preclearance requirement, the Act had a dramatically positive effect on black voter registration in the South, which increased to 62% just 3 years after the Act became law. 6 years ago, however, in Shelby County versus Holder, the Supreme Court effectively gutted the Act's Section 5 preclearance requirement by striking down the coverage formula in Section 4 that determined which jurisdictions would be subject to preclearance. The court's majority claimed that there was no evidence to support Congress's finding of continuing discrimination in voting in these states, notwithstanding the thousands of pages of recorded evidence compiled by this subcommittee in 2006 demonstrating the continuing need for this coverage formula. And despite Congress voting in overwhelmingly bipartisan basis to reauthorize these provisions, it was like 390 to 30 or something like that, because it was American as apple pie. And it's still American as apple pie. Tellingly, in response to the court's decision, states that have been subject to the Act's preclearance requirement wasted no time in pursuing voting restrictions that once again undermined minority voting rights. The measures included strict voter identification requirements, restriction or elimination of early voting or same-day registration, and bans on ex-offenders from voting, all of which make it disproportionately harder for racial and ethnic minorities to vote. In short, this was the Jim Crow era, Part 2. In the absence of the preclearance requirement, it would be extremely difficult at best to challenge all of these new voting restrictions under what is left of the Voting Rights Act. As many of our witnesses will explain today, the remaining enforcement-related provisions of the Act that are still in effect, while valuable, are much more limited in their impact and much more difficult and costly to pursue. And it means they go into effect, and people are affected by that election until some court declares them unconstitutional later on. Moreover, in contrast to Section 5 preclearance, some of the Voting Rights Amendment's remaining provisions allowed only for after-the-fact relief, meaning, as I said, that minority voters would first have to be harmed before any relief could be provided. And then you've got people in office that would possibly pass acts harmful to that minority population. The results of all these factors will be that many practices and restrictions that undermine equal voting rights will simply go unchallenged. The Supreme Court was wrong, in my opinion, to undermine the Voting Rights Act. Mr. Sensenbrenner and others had voluminous evidence of the reason why the states were in the preclearance category. Congress must now respond. It's imperative that Congress restore the Voting Rights Act preclearance requirements so as to stay true to the Act's purpose of ensuring equal voting rights for all. It would be a crime if this Congress did not pass another Voting Rights Act, not only because it is really as American as apple pie, but because it is going back and providing a remedy for what was 100 years of intolerance, discrimination, and Jim Crow segregation in most of these preclearance states. We need to correct that, and we need to do it while John Lewis is still with us as the United States Congressman, and he can be there when this is signed into law once again. It's not enough to go to Selma with John Lewis. You need to vote with John Lewis, and you need to respect his opinion, his work, his life's work, and pass the Voting Rights Act. I thank our witnesses for being here, and I look forward to their testimony. And I now take great pleasure in recognizing the ranking member of our subcommittee, the gentleman from Louisiana, Mr. Mike Johnson, for his opening statement.